number C. This is case number C210432. Again, welcome to the First District Court of Appeals. And this is, this is C210157, Crown Asset Management LLC versus Alan Gaynor. If counsel can please, and parties can please identify themselves and their readiness to proceed. We start with the appellant.
Yeah, my name is Alan Gaynor, and I am ready to proceed. I'm pro se.
Okay. And so, Mr. Gaynor, you are representing yourself, is that right?
That's correct.
Okay, so I'm going to turn to counsel for a second, and I'll come back and I'll explain to you a couple things to help you out this morning, okay? Counsel for appellee.
Yes, good morning. May it please the court, Boyd Gentry on behalf of plaintiff appellee.
Okay, thank you. Mr. Gaynor, you're going to have 15 minutes to present your oral presentation, what we call your argument. You can reserve any portion of those 15 minutes for after Attorney Gentry's presentation. So for example, if you reserve 5 minutes, that would give you 10 minutes. And then after Attorney Gentry, then you would have 5. Like I say, you can reserve any amount that you like. Would you like to reserve time, and how much would you like to reserve?
I would like to reserve 2 minutes, but I had not realized that the the judges can interrupt me and ask questions. So I had timed my oral presentation basically for 12 minutes, but
Okay.
we'll do what we have to do.
Understood. Okay. Yeah, I mean, we ask questions because obviously we want to get to any, questions that we have and anything that we want to clarify.
I'll do my best to. This is the first time I've ever been in a courtroom to speak, so I'll do the best I can. Thanks.
Okay, no worries at all. So that gives you 12 minutes. And Mr. Gaynor, you can start whenever you're ready.
Okay, then. I will do that. 1 second. There we go. Good morning, fellow workers of the court, Judges Zayas, Winkler, and Bach of the Appeals Court, and Mr. Winters and Gentry, counsel for the plaintiff. I would like to reserve 2 minutes of my time for a response to plaintiff's oral arguments. This tale of disillusionment, which is a good thing, is primarily for my daughters. I intend to speak to everyone as my equal. I especially want those without law degrees to understand my remarks. As is customary for technical writers like me, I will define special terms, especially my idiosyncratic noun phrases, before I use them. I won't define terms like idiosyncratic, which you can look up in Wikipedia. A mortal of misfortune is a flesh and blood human being that has had the misfortune to lose a job, have an accident, or get a disease that led to an inability to pay a debt through no fault of their own. I am a mortal of misfortune because I lost my job by layoff, not for cause, and was unable to find another. Every mortal of misfortune has a story that deserves respect and consideration. Corporations like Crown Asset Management LLC and Levy and Associates LLC are artificial persons before the law. They are artificial persons that were created in perpetuity to accumulate wealth, and they have owners. Euphemisms aside, any person, artificial or natural, who has an owner is a slave. An owner of a slave is a slave owner. Because these immortal corporations were created only to accumulate wealth through profit, I call them immortal slaves of fortune. That is what they are. I call their owners slave owners because that is what they are. The state courts in Ohio, including this appeals court, are also immortals. They were here long before the judges in court today were born and will be here long after they have passed. The courts are a special kind of immortal because they purport to represent the citizens in their quest for truth and justice. In fact, the judges in court today are elected officials. Consequently, I call the courts immortal representatives of truth and justice for the people. We are here today because I strenuously objected to the trial court judge granting a continuance at plaintiff's request just when I was prepared to appear in court to make the case that I have now made in my final brief. I objected to the continuance because I knew that I was moving out of Ohio to avoid homelessness in Cincinnati. When mortals move, their lives are disrupted. I knew I would not be able to represent myself adequately during that time, and so did the lawyers for the plaintiff. Despite acknowledging my objection, the trial court granted the continuance, and I was effectively prevented from pressing my requests for discovery in a timely manner or presenting my arguments in court by the summary judgment that quickly followed. All I was able to muster was my ill-titled affidavit for trial. Let me be clear, at the trial court level, I did not want to go to court. I explicitly requested an out-of-court settlement in pretrial negotiations, and I did not want to represent myself. However, once I realized that no lawyer would represent me at a reasonable cost and that my income was exempt from garnishment because I live only on my Social Security, I resigned myself to my pro se defense at trial, and I turned my attention to the redacted complaint itself. As an amateur logician, I quickly realized that as a consequence of the redactions and omissions, the complaint neither proved ownership of the debt obligation at issue in the case, nor that I had digitally signed the redacted promissory note included there. There were no notarized affidavits of the signatories of the debt obligation sale, and the integrity of the document was destroyed by the redactions. Additionally, there was no digital artifact for a signature that included cryptographical non-repudiation. After answering plaintiff's discovery requests in a timely fashion, I drafted my own discovery requests and submitted them. However, plaintiff's savvy lawyers were neither timely nor responsive to my requests, as their professional code of conduct requires. Instead, they took advantage of my inexperience and delayed, denied relevance, and ignored my legitimate discovery requests. Since I did not realize that when confronted with such tactics, I should have asked the court for enforcement, I missed my opportunity to get responsive answers to my legitimate discovery requests. Unless this court remands the case to the trial court level, it appears that the cheating in that way by plaintiff's law firm will be rewarded. And so I came to understand that plaintiff believes that it has a right to what I call a veil of inscrutability. A veil of this kind is like a curtain behind which plaintiff could hide embarrassing information, like what they paid for the debt obligation or the profit rates they enjoy. For example, they ignored my pretrial request for the price they paid for the debt obligation at issue in this case. They redacted the complaint improperly by hiding information that was not personal. In so doing, plaintiff and its law firm destroyed the integrity of the document and prevented any detection and analysis of its possible manipulation, as I showed in my final brief, Appendix C. Then they stonewalled my legitimate discovery requests. Without justifying their redactions, they expected the trial court to validate the complaint without scrutiny. That is what the trial court did when it issued its summary judgment. The plaintiff and its law firm did all of this with impunity because they know that the courts will protect their veil of inscrutability. As a first-time pro se defendant, I was under the illusion that I might be able to pierce the plaintiff's veil of inscrutability by appealing the summary judgment. After the appeal was approved, I reached out to Mr. Winters via email to attempt to get him to correct his firm's egregiously unruly behavior with respect to my discovery requests. He graciously informed me that no discovery is permitted at the appeals level. Basically, he said, "Snooze, you lose, we got away with it." And so I was disillusioned in that respect. And that was not my last disillusionment. I was still under the illusion that if a constitutional issue were revealed during an appeal, that the constitutional issue would be addressed as a priority, overriding local rules. After all, I thought, the Constitution is the law of the land par excellence. Working under that illusion, I began mining data from the Clerk of Court's website. I downloaded all the data for all the cases handled by Levy and Associates in 2019, the last year before the pandemic. I created a database, developed graphics, prepared tables, and wrote a narrative that tied together, all of my research. As an amateur logician, I prepared an appendix that used the propositional calculus to prove the validity of a formal analogy, and I based my legal argument on those solid foundations. That motion used the data from the Clerk of Court's own website to show that Levy and Associates, their clients, and the Hamilton County courts together formed a system of wealth extraction. That system takes the wealth of defenseless Hamilton County mortals of misfortune out of the county and out of the state, distributing it across the country as profits to the slave owners of the debt buyer clients of Levy and Associates, like Crown Asset Management. That system, I showed, extracted more than $3 million from the county that year, and it did so in a biased fashion. I showed that the over-extraction of wealth from some zip codes corresponded to those in which Black and African Americans were overrepresented. How coincidental. And the magnitude was not inconsequential. Some such zip codes had almost 4 times as much wealth extracted from them as one would expect from their population, hardly equal protection under the law. So that motion showed that the clients of Levy and Associates are a special kind of immortal slave of fortune. They are socioeconomic vampires. They are like Alex and his droogs in A Clockwork Orange when they find that tramp, a mortal of misfortune indeed, under a highway overpass and begin to literally kick him while he is down. Like that Clockwork Orange mortal of misfortune, I and the hundreds of other mortals of misfortune set upon by these socioeconomic vampires are defenseless because there is no mandate for public defenders in civil court cases in the home of the brave and the land of the free. Surely such behavior is untenable, I thought. However, the court disillusioned me again by ruling that my motion was, quote, not well taken, unquote. I had no idea what that meant. So I decided to ask the court what it meant. When I filed a request for the court to explain its ruling, it responded that my request too was, quote, not well taken, unquote. I concluded that in order to protect the veil of inscrutability of the plaintiffs, the court had wrapped itself in a similar veil. Perhaps, despite being elected by the people, the justices on the court were not the immortal representatives of truth and justice for the people that I had imagined them to be. Undaunted, I reminded myself that my true goal was to show simply that the plaintiff and its law firm, by relying exclusively on the improperly redacted complaint, had not met the burden of proof they assumed when bringing the complaint to the trial court. That is what I demonstrated, very effectively in my final brief. I realize now, however, that I was under the illusion while I was writing that final brief that this appeals court could provide the relief that I asked for there. I expect to be disillusioned again in that respect. I have spent almost 2 years of my life struggling to be disillusioned enough to get the help of the courts to pierce the veil of inscrutability that the plaintiffs presume they have a right to enjoy. During that time, I have struggled to find shelter and the simple accommodations necessary to write the motions and briefs I've presented. Last fall, after trying for almost 3 years, I was finally granted a job interview. I aced the interview and was offered the job. However, by that time, I was homeless, living in my tiny car and at a nearby campground. I had to turn down the job because the salary was insufficient to permit me to get an apartment. I was able to complete my final brief only because of the solidarity of a good Samaritan who allowed me to sleep and work out of one room of her house. I know that life is not always fair, and it is not the job of the courts to ensure fairness. I also know that laws can sometimes be passed that make life for defenseless mortals of misfortune like me and the hundreds of us every year in Hamilton County that are affected by the operation of the immortal vampire slaves of fortune like Crown Asset Management and its debt collector law firm a bit fairer. Finally, I realize, and I hope the court does too, that such beneficial laws only happen when the intolerable abuses are not protected by a veil of inscrutability. Legislators need to know of the abuses to write enlightened legislation, and the public needs to know of them to hold the legislators accountable. If the courts are the immortal representatives of truth and justice for the people that I imagine they could be, then they have a role in the democratic betterment of the fate of defenseless mortals of misfortune like me. In the contest between these immortal vampire slaves of fortune and the defenseless mortals of misfortune that seek only to shine the daylight of public scrutiny on the profits of the vampires, whose side are the courts on? Please find a way to strip away the veil of inscrutability that protects the immortal vampire slaves of fortune so that the people and their legislative representatives can act in an informed and humane way. Send this case back to the trial court with the admonition to conduct discovery and scrutiny of the complaint in accordance with the law and the appropriate placement of the burden of proof if you are not able to do that in this appeals court. Ask also, please, for plaintiff's law firm to respect the rules of professional conduct that presumably apply to that firm. I will do my part by filing a complaint with the appropriate bar associations for the egregiously unruly behavior of the firm to date. Thank you.
Thank you, Mr. Gaynor. Attorney Gentry,
Yes, good afternoon.
good afternoon.
Much of appellant's arguments are made for the first time during this appeal and not made during the course of the trial court's jurisdiction. The underlying facts that were presented to the trial court on summary judgment were ultimately adopted by the court in granting summary judgment because appellant did not produce facts to disagree with those. The affidavit filed by appellant in response to the motion for summary judgment simply did not disagree with the basic facts. Despite appellant's zealous and very active representation of himself, the basic facts were borne out in the trial court that WebBank opened an account for Mr. Gaynor at his request and funded that account and advanced money to appellant Mr. Gaynor. The materials submitted with the motion for summary judgment demonstrate that some payments were made toward that loan, but the loan was not paid in full. The balance showing the payments and the application of payments was submitted with the motion for summary judgment. Those essential facts were not contested by appellant's affidavit. Appellant did not say in the trial court that he did not open this account. Appellant did not say in the trial court that he opened the account, but the amount was actually different that he received than what was disclosed in the truth in lending disclosure.
It sounds to me as if he was challenging not whether he opened the account, but whether the plaintiff had established that he opened the account. Sounds like he was challenging the formation documents when he was talking about the initial signatures and things of that nature.
That appears to be his arguments now that he does not, appellant does not accept the promissory note with the phrase electronic signature. That phrasing, I guess, of electronic signature is not the issue. The issue is, did he actually open a loan? Did he actually provide an electronic signature? He does not indicate or did not indicate in the trial court that in fact he did not provide an electronic signature. Nowhere in appellant's filings, either in this court or in the trial court, does he say, I did not sign that electronically. The documents indicate that electronic signature was received and accepted by WebBank. Appellant does not contest that. Instead, he contests of how it looks when the document is printed on paper and submitted to the court.
Did he challenge below the formation documents? Did he challenge that what he seems to be arguing here, that the plaintiff did not establish that there was a contract?
I'm reviewing that affidavit now, and it's difficult to interpret for me, but the affidavit filed calls the loan a pretend loan and says that the plaintiff has not carried its burden of proof. But I don't see anything in that affidavit that was filed in opposition to summary judgment that says, I challenge the signature, or the signature is not there, or it doesn't work, or something like that. I don't see that in there. Instead, what I see is
So-
characterizations.
Because what I understand his argument is that this doesn't suffice, that this electronic, this notation doesn't suffice to establish that he had signed and taken on the obligation.
And I do not see that in appellant's affidavit filed in response to the motion for summary judgment.
Now, he also raises some concerns with regard to response to discovery requests. Can you please address that?
Yes, a large number of discovery requests were directed to the plaintiff appellee. Plaintiff appellee's counsel and the trial court responded to those. Appellant now complains that he should have been entitled to more information, such as the purchase price that Crown paid to obtain the assignment of the account. And he claims that he needed to see all of the other account information, or better said, the information for the accounts of other persons to conduct his defense. Those were objected to as irrelevant. The price matters not to whether Mr. Gaynor or appellant opened the account, received the money, agreed to the written terms.
So there was a determination that the request for purchase price and those matters were not material to the issues before the court. Is that what you're saying?
Yes, counsel objected on that basis, and
That was the objection. Was that the determination of the court?
the court did not make a determination because the issue was never presented to the court. As appellant outlines here, that he did not bring it to the attention of the court to say he needed some additional information to oppose the motion for summary judgment.
So there is no motion to compel.
Correct. Correct. And so the discovery was responded to.
And with regard to the requests of other accounts, was that addressed through objections or determinations by the court, or both?
Objections from counsel. I do not believe there were any discovery determinations by the court because there was no motion filed by appellant or appellee on discovery. So and this, like many of these issues, are coming out now on appeal, and appellant is trying to assign them as error in the trial court, when in fact the trial court did not make those determinations or did not even consider those issues because they were not before the trial court. And so it would be odd to now say that the trial court made an error in those respects. The affidavit attached to the motion for summary judgment, the written promissory note with the payment history are sufficient and were sufficient to meet plaintiff appellee's burden on summary judgment. And we would request that the court affirm the summary judgment. I have nothing further to argue, but I'm happy to answer any questions with my time.
Are there any questions from the panel? All right, thank you, Attorney Gentry.
Thank you.
Mr. Gaynor, you had reserved 3 minutes, which left you with 12 minutes to argue. You only had used 11 of the 12 minutes. So I'm carrying over the 1 minute and you have 4 minutes on rebuttal.
Oh, really? That's surprisingly good. I won't need much.
Your audio is breaking up and I'm not able to understand you.
Can you hear me now?
Fairly well, not as well as previously.
Entirely sure what I can do. I am unmuted and I'm speaking.
I mean, it looks like your
directly
internet feed is
to the
very
microphone
choppy.
As far as I can tell.
Mr. Gaynor, are you able to hear me?
I can change.
Are you able to
I
hear
am,
me?
yes.
Okay, so it looks like your internet
Yes.
is not very good at this point, and so it's very choppy. And while the volume is okay, the ability to discern your words are not very good right now.
Well, let me see if there's something I can do about that. No, this is probably the best I can do. So this is only a problem now. It wasn't a problem before.
And is it
Sorry,
just
can you
my
hear me at
system
all?
or is other able?
I can hear him, as long as he speaks slowly, I think we'll be fine, but,
Okay.
it definitely is not as good as it was.
Okay,
Well, I can try to reset my internet and maybe that.
Attorney Gentry, are you okay with Mr. Gaynor resetting his internet?
Of course, of course.
Okay, Mr. Gaynor, we'll go ahead and do that. No, he's frozen. Hopefully he heard. Okay, so we're gonna all turn off our mics.
Yeah. I could call in if you want me to do it that way. I'm not hearing you either now, so
Okay, yeah, go ahead and try calling in. I think that's a fantastic idea. What you want to do is turn off your microphone on your computer because you're going to have there's going to be an interference that'll be caused if both your computer microphone and your cell phone, which is right
Right.
adjacent to it, are on at the same time. So you
gotcha.
can leave your video on, but turn your microphone off and call in, okay?
Just the telephone number. Sorry for the technical difficulties there. Oh, boy. Um, 929 205 6090.
The wireless customer you called is not available at this time. Please try your call again later. Announcement 1. The wireless customer you called is
Okay, let's try it again. Sorry.
Mr. Gaynor, it looks like your video is now good. Speak and let me see if it's smooth.
I don't know. Is it the video that's lacking and the sound is fine?
Yeah, try.
Hold on. I dropped my microphone. Right. Okay, it's on now. Can you hear me?
Yeah, go ahead and call in.
Okay, yeah.
Mr. Gaynor, if you look in the chat, the information for calling in is in there and it has been sent by the court.
99. Well, I'm. Okay. 879 5246 2018. 824871. Oh boy. 824871. Okay, 879-5246-2018. Eight, 24871. Can you hear me? Can you hear me?
Yes.
Let me turn off my microphone. Okay, can you hear me now?
Perfectly. So you have 4
Okay, can
minutes
you
to
hear me now?
argue, and you can go ahead,
Yes.
and you can go ahead and proceed, please.
Okay, so I just wanted to say that I don't feel that it's true that I didn't object. In that affidavit for trial, I raised all of the points that I've raised in this oral. Is my computer still giving feedback?
Your microphone is actually on. You have to turn your microphone off. So if you move
that
your
work?
cursor to there you go. Perfect. Perfect.
Okay, so I really apologize for the technical difficulties. So in that affidavit for trial, I raised all of the points that I've raised here, that they had not proven that they owned the debt obligation at issue, and so on. We can go back and look at the text of it if that's necessary, but the fact of the matter is I did raise those points. I didn't raise them as a motion. I raised it as an affidavit for trial because I didn't know what I was doing. If I had had legal representation, I am sure that I would have been, and the other issue is I was not asking for anybody else's information. The only information I wanted, and Appendix C in my final brief details this, I was just asking for that information that would allow me to ensure that the document from which they had extracted what they put into the complaint was actually an integral part of that document. I wanted to be able to reassure myself, but I would say also to reassure the court, any court, that they had not just taken this, made it up from whole cloth. Okay, I mean, I know we're supposed to trust these people because the law firms and the corporations always do the right thing, but they're motivated by profit, and I don't trust them in that way. And so I wanted them, if they're going to bring if they're going to bring a complaint to trial, they should prove that they actually own it. And the way I proposed that they prove it was to provide an anonymized version of the document from which they took presumably my account information, and to ensure that that was actually the document that that they had purchased from the original lender. And so just the last thing I guess I'd like to say is they provided no information during the discovery. They answered one question, like I asked them, was 2 + 2 = 3, 4? And they said yes. Everything else they denied, they objected to. And since I didn't know I was supposed to get a judge to look at whether or not those denials were appropriate, it never came up in trial because I was pro se and ignorant, frankly. I think that's all I have to say with respect to that. Thank you.
Thank you, Mr. Gaynor. Thank you. Thank you both for your arguments. Thank you, everyone, for your patience, but it was important to be able to fully hear all of the arguments in this case. We will take the matter under submission, issue a timely decision, and we wish you both a wonderful afternoon.